Hello, this is Matt on the Moon Lambeau channel. The SEC just won on a fair notice defense argument in a case that they're claiming is similar to the case that they have brought against Ripple. And as we know, Ripple's fair notice defense, which Judge Torres still needs to rule on, which Jeremy Hogan thinks will happen perhaps February-ish is the word that he recently used. This is highly consequential. If Ripple is allowed to utilize their fair notice defense in this case, there's a higher probability than there otherwise be of the SEC coming to the table to settle. Because the fair notice defense has teeth, and it's just a matter-of-fact thing that if the court finds that Ripple did not have sufficient notice from the SEC that what they were doing was illegal, then the case is over. As a matter of law, it's done. Ripple wins, that's it. And that would set precedent and be very bad for the SEC. So if the fair notice defense stands, don't be surprised if there's going to be some sort of settlement. But here, the SEC is claiming, and they filed a document indicating as much, that they won in what they're calling a similar case. They won on this matter, excuse me, of fair notice. But here's the thing, and I'm going to read through the document here. And I think you'll probably find the same thing as me, which is that this is just another document that the SEC has filed that needs to be added to their pile of documents that contain just nothing but deception and lies. Because that's all that's going on here. This is deception. I don't believe that they believe the argument that they're making. So fine, on the fact it's true. They won in a separate case, unrelated to Ripple, something pertaining to fair notice defense. So the defendant was making technically a similar claim, but my gosh, the cases are dramatically different. And that's already clear. I'm not pretending to have read deeply into this case that they're citing here, but you'll see for obvious reasons, they're not even close to the same thing. Like, even before reading the details, you'll know this, and you'll see why in just a second here. But look, before delving in, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out to XRP community member and attorney James K. Filan, who shared this document just within the last few hours or so, and he wrote the following: "The SEC has filed a letter of supplemental authority in support of its motion to strike Ripple's fair notice defense. Below are the letter and the case the SEC relies upon." And so the reason that the SEC filed this is to kind of nudge at the judge and say, hey, see, this fair notice stuff, it doesn't stand up in court. That's effectively what they're trying to say. But my gosh, the circumstances couldn't be more different, and they're being deceptive. I don't think they actually believe that they're sufficiently similar to make this, to actually file this. I don't believe that they believe that because it's illogical, but they're arguing that. But they argue all sorts of stuff that's completely illogical. How many non sequiturs have we seen from the SEC over the last year? Like infinity, effectively? They don't care. These people are bad people. They are assets. I do not like them. Here's the deal, though. They wrote here, and this is the relevant portion where they're making the initial claim anyway. There's this case called SEC versus Fife. And they note that in this, the court rejected the Fife argument at the pleading stage, and they note that it was the same fair notice argument Ripple asserts in the case, and that the SEC has moved to strike. So it's only the same in the sense that fair notice is an actual legal defense that you can apply to your case if you're a defendant. That part's similar, but that's it. It's just something that is called the fair notice. It doesn't mean that any of the other facts and circumstances are remotely similar. In fact, take a look at this. Take a look at this. This is from, I think this, if I pulled up the right one here, I think this is the right one. Yeah, SEC versus John M5 Chicago Ventures Partner. And you can see the headline at the top. SEC charges unregistered penny stock dealer. Folks, let me ask you something. When it comes to traditional finance, when it comes to the stock market, including penny stocks, do we think that there's a lack of clarity surrounding that? Is there anybody operating just in traditional finance, stocks, hedge funds? Are there any firms out there that are complaining that there's not sufficient regulatory clarity around stocks, including penny stocks? Is there any of that? Is anybody claiming that? No, because that would be stupid. STOOPID, stupid. Nobody thinks that. That's a different asset class entirely. So yes, fine. Fair notice defense filed. Got it. Fair notice defense filed. But it's in legacy finance and something where nobody disputes whether or not there's clarity. Now, in the SEC versus Ripple case, you're talking about a brand new asset class, the first new asset class in hundreds of years, mind you, which is very different because when it comes to whether or not something is a security, there's this idea of common enterprise. And can there be a common enterprise if a cryptocurrency is sufficiently decentralized to the point where nobody has control over it, no individual person or entity anyway? Can that still be, because that doesn't satisfy a prong in the Howey test. And you can, and so that, consider that, and then look at how the SEC has gone after the entire space. How is it that nobody in the space in the United States thinks that there's sufficient clarity except for the SEC? It could not be more clear. There's not sufficient clarity. Different asset classes. Yet these pricks at the SEC are pretending that these are the same things. There's no way they believe this. There's no way you'd have to, and because they're not stupid, they're just bad people. They are not stupid, they are bad people, and they're liars, and they don't believe this because it's not logical. But this is what they're doing. They're throwing everything they can and seeing what can stick, and if they can trick the judge into thinking this nonsense crap, then yay for them, that's what they're thinking. But if I'm the judge, I'm sitting here thinking, how stupid do you think I am? This is illogical nonsense. And of course, I'd be an adult civil judge about it and not say that, but maybe I'd be thinking that. So take a look at this. Here's how the letter reads. Fife involves the broad statutory term dealer, like Ripple's arguments here regarding a different and similarly flexible statutory term investment contract, SEC versus W.J. Howey Co. The Fife defendants contended, quote, they did not have fair notice of the SEC's novel interpretation of the statutory term dealer, end quote, when they engaged in the conduct about the SEC now, which the SEC now complains. Pause. Think about this. Don't you think, for good reason, it would be very difficult to make such a claim successfully in a world where nobody thinks there isn't sufficient clarity? Because we're talking about, again, the stock market. Not even close to the same thing. SEC then wrote the following. The Fife defendants specifically argued that the SEC's regulatory guidance not only lulled defendants into thinking that their conduct was appropriate, but actually encouraged that conduct. Rejecting the defendant's argument, the Fife court agreed with the SEC that, for purposes of assessing fair notice and due process, quote, the standard against which the SEC seeks to measure defendants' conduct is the statute itself, the language of which defendants and all others even arguably involved in securities transactions plainly have had notice, end quote. The court accepted the same argument the SEC has advanced in this case, concluding, quote, it is for the courts, not the parties, to determine whether particular conduct falls within the scope of the statute, end quote. And again, this is why it's so ridiculous and absurd. It's offensive reading this. Seriously, this is really steaming my vegetables. They're ruined. They're a soggy mess right now. They're completely oversteamed. And it's because they're claiming, this is the claim that they're making, it's that the facts, because they'd have to believe this if they were making this claim. Not that they actually believe it, but you'd have to trick the court into believing that you believe this and then convince them that the facts and circumstances are sufficiently similar in order for this. Because again, the only similarity is the term fair notice. These are completely different aspects of the world of finance. Completely different aspects, completely different facts and circumstances. It's just ridiculous. I don't care for it. Have you gathered? I don't care for this. This is what they're doing, folks. Oh my gosh. It's like, go home, SEC, you're drunk. I don't want to deal with this anymore. This is why we can't have nice things. This is why we cannot have nice things, you freaking asshats. Okay, I'm going to simmer down now. You all tell me what the hell you think, but this is how it struck me initially. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.